Hello and welcome to another edition of Coffee Talk with immigration attorney Brian D. Lerner. In this particular video, I'd like to talk a little bit about the memos that were just put out by the DHS Secretary in regards to essentially enforcing the executive memos or the executive orders that were put out by Trump. Now, uh, there's a couple things that we need to discuss here. First, if the executive order itself, if certain parts of it are not constitutional, and in fact, they were found to be unconstitutional through the court because lawsuits were brought, then an executive memo by the Department of Homeland Security cannot override essentially the courts, the law, and the Constitution in essentially a backwards path or manner in which to try to obtain and get the results which the executive order was intended in the first place. So, given that, um, once a policy memo is put out, it can be torn apart and lawsuits can be brought and actions in federal court can go forward if it is determined that the policy itself is either vague or ambiguous or that it violates the law. It cannot be used as an end run to try to enforce items upon which the executive order itself is not enforceable or unconstitutional. Let me give an example. In one of the orders that were just put out, or in one of the memos that was just put out by the Secretary of Department of Homeland Security, it essentially said, one little paragraph of it, or two sentences, it said that if the person is not a U.S. citizen and is not a lawful permanent resident, that essentially no privacy rights can be afforded to that person. Well, first of all, the memo itself is unclear as to what privacy rights they are referring to, what law they are referring to, because the memo itself didn't specify any law whatsoever, any statute, any regulation, any cases, nothing. So it's unclear. Does that mean that if they're living in their home, that DHS officers, let's just say they're here on an H-1B. They're not even here illegally. Let's just say they're here on some non-immigrant visa, but they don't have a green card. That means they've been properly admitted, that everything's been approved by USCIS, that they have been, admitted and vetted, as Trump would say, at the border, and that they are legally inside the United States. Does that mean, by this statement in this particular memo, that if they're, for example, in their house watching TV, that DHS officials can just storm in their house and take them, or that DHS officials can storm in their house, take their cell phones, and look at every communication that they've had for the last month, or that DHS officials can come in, or that local police officers working to help DHS, which by itself is a constitutional issue, can come in and search their whole house because they believe they may or may not have done something illegal? The answer is no. That can't be done. If somebody is here in the U.S., even if they are not here legally, or even if they have not been admitted, but they're in the U.S., they do have certain constitutional rights as to what they can and cannot do, or what the government can or can't do against them. Now, in regards to another part of the memo, it looks like, and we haven't received it yet, but I guarantee I'll do a video the moment it comes out, that the expedited removal statutes are going to be expanded. Now, what is expedited removal? Well, that falls under Section INA 235, and it essentially says that somebody can be removed from the United States by an officer, an immigration officer, who is acting as judge, jury, and executioner, all of them, and without any review, without any foresight, and essentially, without the proper training, can remove somebody from the United States without having to see an immigration judge, in which all of the due process procedural safeguards are there. And in today's day and world in the United States, having due process safeguards is an absolute must. If there were no due process safeguards afforded by the courts, um, it is very likely that people would just be thrown out of the country without proper process, in violation of multiple provisions of the Immigration and Nationality Act and so forth. So it is critically important that if somebody is going to be expeditedly removed, that they fall under the statutes which allow for expedited removals, and that they are not improperly removed from the United States if they don't fall under the expedited removal statutes. Now, as it stands right now, today, the if somebody comes into the United States illegally and they're caught at the border, and they have no legitimate papers, they can certainly be expeditedly removed. And one of the ways that they can get in the country is if they have a credible fear of persecution in their home country, upon which the officer is supposed to ask them and give some kind of statements as to their rights in regards to this. It's turned out that a lot of officers basically don't ask this and don't take any statements from the detainees. But at any rate, the expedited removal will also work essentially if the person has been inside the United States for less than 14 days and they are within 100 miles of the border. That's the current law. Um, Now, there's one item, which this is statutorily written, that the if the person has been in the United States for more than 2 years, they cannot be expeditedly removed. This does not matter what crime they may have committed or didn't commit. If they've just been here illegally and have been working, if they've been convicted of an aggravated felon, whatever it is, um, if they've been here more than 2 years in the United States, they have a right to go in front of the immigration judge. And if they don't like the order from the judge after going through immigration court proceedings, they can appeal that to the BIA, which is the Board of Immigration Appeals. And if they don't like that, they can do a petition for review to the Circuit Court of Appeals, upon which they'll hit federal judges. And if they don't like that, they can do a petition for rehearing en banc and or go to the U.S. Supreme Court for writ of certiorari. Now, while some people watching this, will say, well, if they committed a crime, kick them out of the U.S., period. Well, our country doesn't work like that. Our country affords due process in order to make sure that we don't turn into a country where the moment somebody may or may not have committed a crime, may or may not be inadmissible, and so forth, that some officer who has 3 months of training cannot just take a person and basically determine on their own, without any oversight, without any education necessarily in the law, and just throw them out of the country. The due process rights afford everybody due process rights, even those people who would respond that anybody who's committed any crime whatsoever should be kicked out of the country without any due process. They themselves will most likely and someday find themselves in a position where they will be afforded due process, just like anyone else who is here should have. So my suggestion, especially when the new memos are going to come out, which will increase most likely the area of availability that they will start doing the expedited removals is you should have on you documentation, which a law office, immigration law office, should be able to provide you, and showing, number one, what the law is on expedited removals, why, especially if you've been here more than 2 years, why you are not subject to expedited removal, and what your rights are, why you're not going to sign a voluntary deportation paper, and why you want and are afforded under the law the ability to fight your case in immigration court in front of an immigration judge, and one that affords oversight, judicial review, and administrative review of the particular decision. And you should have in that legal document attachments showing proof of where and how and why you've been here for more than 2 years, so that you clearly will show that you are not subject to expedited removal. Before, if we were talking a month or 2 months ago, this video would have never been made. But based on the actions of, the president and what's going on, it's necessary to protect yourself in a manner that was not necessary before. So if you like the video, click like, subscribe. More videos coming as the current events fold out. Okay,